Hi, Harris from Queen City Law. Last week, I appeared on national TV and provided a brief expert view on one's deportation liability due to criminal convictions.
Under Section 179 of the Act, once they're deported, they will be permanently prohibited. It really depends on the seriousness of the crime and the time the offense took place.
I think it's an interesting topic to explore. If you currently hold a visa or have applied for a visa, you might want to tune in. I'll start with temporary visa. Temporary visa includes visitor visa, student visa, and work visa. Under these circumstances, you can be held liable for deportation. First, you hold a visa under false identity. Second, when Immigration New Zealand determines that there's sufficient reason to deport you. And sufficient reasons includes, but it's not limited to, your visa condition, criminal offending, other matters related to character, or your circumstances no longer meet the rules or criteria under which your visa was granted. Now I want to expand on deportation liabilities due to other matters related to character because I often see clients caught in this situation. A typical scenario is when an applicant engaged an overseas unlicensed agent to prepare their visa applications. The agent will not declare the details in the application form due to the unlawful nature of their representation. The application would therefore appear to have been submitted by the applicant themselves. One day, after the applicant have arrived and settled in New Zealand, they will find a letter in their mailbox from Immigration New Zealand asking them to leave because they provided false or misleading information in their visa application. They were shocked and told INZ that they were innocent because they did not provide the information, but INZ did not care and told them that it's their responsibility to ensure that all the information they provided in support of the visa application are true and are not false. And if they do not leave New Zealand immediately, they could be banned from entering New Zealand for 5 years. Now on to the resident visa. Resident visa gives you the right to work and live in New Zealand permanently, but that doesn't mean you can do anything you want. You could be held liable for deportation under circumstances similar to those described for temporary visa holders. Again, for the same reason, I will talk about deportation liabilities due to matters relating to character. A typical scenario is when an applicant unintentionally withheld a piece of information which, if provided to Immigration New Zealand, might alter the outcome of their resident visa application. The information could be change of address, change of employment, civil disputes, and etc. Unfortunately, element of the intention is irrelevant here, so one could face deportation over an honest mistake. And INZ will tell them if they do not leave New Zealand immediately, they could be prohibited from entering New Zealand permanently. I guess now the question from you is what can be done to either prevent this from happening or how to deal with it if this happens to you. First and foremost, if you want to use an advisor, do not engage an unlicensed agent. Always make sure that you're represented by a lawyer or licensed immigration advisor, otherwise you run the risk of getting deported. Secondly, when you find yourself liable for deportation, seek immediate independent legal advice. It's not the end of the world and we're here to help. As over the years, Queen City Law have helped many clients secure their residence after being held liable for deportation. I hope this video is of assistance, and if you have any questions, please feel free to reach us.